Hello, everybody. So, welcome back. So I'm going to be looking at judicial precedent in this talk today. So, this is a core doctrine of English law and of common law more generally. So, this means that judges have to look at previous decisions, precedents, and they generally issue their rulings in line with precedent. If something was allowed before, it should be allowed again. If something was forbidden before, it ought to be forbidden again. Cases with a similar factual basis ought to be decided in the same way. It stands to reason. So we do this to provide consistency, and so we know what the situation is, what's permitted and what is impermissible. Judges, they give their reasons for their judgments. They don't just say the claimant wins or the defendant wins. Why? They must give reasons, and that assists their judicial colleagues. It promotes certainty and predictability. And then the people are helped with litigation in future, knowing what that is. They can draft contracts cognizant of judicial reasoning. Anyway, some precedents are non-binding, are advisory rather than compulsory. So what is binding precedent? So that is, as you're tied to it, you must follow the precedent. Stare decisis is often sometimes pronounced other ways, as in stand by the decisions. So you must go along with previous decisions. And then we can tell what the law is going to be. We can reduce the number of disputes. It's better if people actually know where they stand. So that's been around for centuries. Remember, courts go up in tiers. In the criminal system, magistrates court, up to Crown Court, up to the Court of Appeal, criminal division, up to the Supreme Court. Whereas in the civil law system, it's the county court to the High Court, to the Court of Appeal, civil division, and finally the UK Supreme Court. Anyway, so Parliament can change this, and the courts, as I say, they can't overturn legislation. So stare decisis, it makes things predictable. It means that the whole system is coherent and supposedly just. So the Supreme Court, they underscored yet again the primacy of precedent. There's a case called Willers and Joyce 2016, and here is the judgment from the Supreme Court. In a common law system where law in some areas made and the law is in virtually all areas developed by judges, the doctrine of precedent, or sometimes known as stare decisis, is fundamental. Decisions on points of law by more senior courts have to be accepted by more junior courts. Otherwise, the system becomes anarchic and loses coherence, clarity, and predictability. Close quotation. All right. So we have to see that this limits what the judiciary can do. And the judges came up with it themselves. Parliament didn't pass that as a law. But in 1966, the House of Lords, which was then the Supreme Court, they decided they were actually going to go against one of their precedents. But they said that in future, they would usually be bound by precedents. There had to be an overriding good reason for them to break with precedent. So some precedents are simply persuasive, as in not binding. So they would generally go along with it, especially from other jurisdictions. So very persuasive precedents would be a ratio, as in ratio decidendi, reason for deciding, from the Judicial Committee of the Privy Council. For some countries, like in the West Indies, this was their Court of Cassation. The ratio of a superior court within other common law countries, decisions of High Court judges, which High Court judges regarded as highly persuasive. Especially where the decision has been issued after it was reserved, i.e. they took some extra time to ponder it before issuing it. Now there's a vertical and horizontal precedent. Okay, so vertical precedent is a lower court following the decisions of a higher court. So, for instance, the High Court is bound by the precedent of the Court of Appeal and the UK Supreme Court. Then horizontal precedent is a court following its own previous decisions. Right, so a magistrate's court following previous decisions of other magistrates' courts. So ratio decidendi, Latin for reason for deciding, and the plural of that is rationes. Well, you could pronounce it ratio decidendi if you wish to. obiter dicta are other remarks made whilst issuing the judgment, which are not actually a part of the ratio. So anyway, so Rupert Cross was a judge who explained why we believe that the ratio decidendi is so important. He said, the ratio decidendi of a case is any rule of law expressly or impliedly treated by the judge as a necessary step in reaching his conclusion, having regard to the line of reasoning adopted by him. Close quotation. So the ratio is not the decision, and indeed there's even a case where they've found for the claimant, but they said blah, 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 but the defendant would win if whatever, but the defendant didn't actually do that, which is why the claimant wins. The ratio, it creates rules which can be applied across the board. So, and remember, I just explained what obiter dicta is. In Ivy and Genting Casinos, UK Limited 2017, here a claimant was a professional gambler, and he used this method of playing his cards. It's called edge sorting, and he won huge sums of money at the defendant's casino. The defendant refused to fork over the winnings, saying he launched some legal action to recover the money. The Supreme Court dismissed the claimant's appeal. The Supreme Court said the claimant had breached the implied contractual term which prohibited cheating, and they didn't need to test whether dishonesty was part of this. Okay, so that's the ratio of the case. Then in the obiter dicta, the court said there's a test for criminal dishonesty which emerged in R against Gauche, 1982. But that said that test was thrown out, didn't count anymore. So Lord Hughes was the judge who said that there's the second leg of the test propounded in Gauche does not correctly represent the law, and directions based upon it no longer ought to be given. Close quotation. So that was obiter dicta. So changing the dishonesty test was a big deal. In Headley, Byrne and Company Limited against Heller and Partners Limited, 1964, there was about negligence, and the relevant reasoning was mostly obiter dicta, oddly. So you need to be able to read a report or a case and say what the ratio is, and then what the obiter dicta is. So then you can provide people with the right advice. So in R. Youngsome against Parole Board 2019, Lord Justice Liggett, he talked about the ratio. So he said, you've got to start with what Sir Rupert Cross said. The ratio decidendi of any case is the rule of law expressly and impliedly treated by the judge as a necessary step in reaching his conclusion. But is this really necessary? Well, this is what Lord Justice Leggett had to say. The ratio is, or is regarded by the judge as being, part of the best or preferred justification for the conclusion reached. It is necessary in a sense that the justification of the conclusion would be, if not altogether lacking, then at any rate weaker if a different rule were adopted. Close quotation. We think that the whole thing hinges on the ratio. There are some situations in which a lower court, when deciding a precedent case, will think that the true ratio is narrower than was actually said in the judgment in the higher case. Lord Justice Leggett said that the doctrine is somewhat flexible, and we can pick out what the ratio is very easily, and there are a number of factors which help us determine what the ratio actually is. And this is what Leggett had to say. In looking for the ratio decidendi of a case, the starting point is always the rulings and reasons given in the judgment to justify the court's decision, read in the light of the facts of the case and the issues that arose. Close quotation. He goes on much longer, but that shall suffice. So the factors are the consensus between the judges. We sometimes look at it in minority judgment, as in those who dissented, they were outvoted, and the reasons they provided for their decision. Okay, so there are 10 factors that Leggett laid out. So the material facts are the facts which are relevant to the case, ignoring any surplusage, just irrelevant remarks made during the case, try to garner sympathy somehow. No. The facts are important, but sometimes the factual basis is different in two different cases, so the opposite decision is made. Look at Donoghue against Stevenson, 1932. The snail in the bottle. Well, it was a cardinal fact here that the bottle was opaque, as in the person wasn't able to see the dead snail. Had there been no opacity to the bottle, perhaps the decision would have been made differently. Okay, distinguishing. This is what judges do, say, no, but this case is different from the other one, even though the same issue, because of the factual basis. So they don't want a decision which would be inapposite in this case being applied. So the Court of Appeal said distinguishing overmuch can make the law incoherent. This is in a case called Sevilleja, Garcia and Marex Financial Limited, 2018. Our starting point is the law as decided by decisions of other courts that bind us. In some circumstances, it is possible for the court not to apply an analogy, an earlier binding decision, when concerning different facts, which concerns different facts. Close quotation. They go on a lot longer, but I think that's enough for right now. Okay, so cases can lose their binding authority, and there are three ways they can do this. Number one, they can be overruled, either expressly or implicitly. This could be by Parliament. Or could, number two, reversal. The case is reversed when the case is appealed to a higher court, which overturns a decision of the lower court. It could be overturned on the facts rather than because the ratio is long. Or number three, overruling. A case is overruled by a higher court, saying dealing with the facts which can't be distinguished from it. The factual basis is very similar, so they either say outright that ratio is overruled, or they produce a ratio which impliedly overrules it because the two are not compatible. So how do you pick out the ratio of a case? It's not easy. It's not underlined. They don't actually necessarily, this is my ratio. These can be pages and pages. And several judges will sit on the case and they'll say, I have nothing to add. So how do you pick out the ratio? Is by analysing things, understanding the case, and trying to pick out the legal principles. So that's enough for the moment. Toodaloo.